Well, here's what some people are talking about. A former Starbucks employee sues his former employer. This is after being fired for trying to stop a robbery at his St. Louis job. Now, he says he was wrongfully terminated since he says he acted in self-defense. Starbucks told Fox Business in these types of situations, the protocol is to comply and de-escalate. So what gives? Employment attorney Alfonso Canard is here on the Factor Uncensored to talk about it. Now, first of all, let's establish that Starbucks had a policy in place, right? As an employee, you're supposed to follow that policy, which I'm thinking was, well, we know, do not engage. So what went wrong here? And should this employee have done? Is this human nature?
Right. And so, Isaiah, I've actually had a case like this before where similarly an employee was terminated for trying to prevent theft from happening in that store. Now here, there's a couple of issues. The first thing is these employees aren't typically trained to engage with armed robbers.
Right.
They are not law enforcement trained or otherwise. So companies want to make sure that they don't have their store clerks acting as undercover police officers or otherwise engaging with someone who has a weapon or can cause harm to not just these individuals, but to other patrons and other people inside the store. Now, when we look at what happened here, the state of Missouri has laws on the books that state you cannot protect or prevent somebody from defending themselves, because at this point there was an assailant already in the premises. This individual, this employee, was already on the ground. He's like, well, it was up to him to decide fight or flight. At that point, he opted to fight. And now it becomes an issue of his own civil liberties. So my company's going to tell me I'm just going to have to sit here and potentially get killed. And he opted not to do it. Some folks would rather just stay down. And the last thing you're thinking about is what policy 11AB on page 187 of the Starbucks manual has to say when you're in that situation. Now, I don't think that this individual should have been terminated for multiple reasons. In this particular location, you saw where his attorney was stating that this employee had already been telling them, look, guys, this is a dangerous location. We've had multiple robberies, multiple attempts at theft, and they did nothing. They did nothing. So now this happens, and they don't want to necessarily be held accountable. But they were on notice, and so there are laws that state if an employer or a company is on notice. Would the state
law supersede what their policy is in their handbook if they say do not engage, but the state law says you cannot prevent someone from defending themselves?
A policy is just a policy. Now, this employer can...
A rule for a company.
Correct. But it doesn't usurp whatever the laws are of that jurisdiction. In this jurisdiction, it's clear. You have the right to defend yourself in a situation like this. And that's exactly what this individual did.
Private citizen or employee, doesn't matter.
At that point, it doesn't matter. You're an individual on the floor with someone who's presented a pistol to you, and you now have options to either protect yourself or not. Now, of course, Starbucks is gonna point to its handbook and say, look, you violated our rules. But the law states that he has every right to do so. So I trust they're going to test it out in court. But I think what's going to be more important for the success of this employee's case is that this particular entity, this company, was on notice that this location has had issues in the past, and it culminated in an unfortunate tragedy like this one.
Now, when you are giving a jury this, what do you tell the jury to follow? Do you tell the jury to follow the policy? Obviously, the store's attorney will say follow the policy. And if you're a defense attorney, you're saying follow the state rule. Which will the jury go for in a case like this if it gets there civilly?
Well, so if you get to the point where there's actually a jury trial, that means that this case has passed muster with the judge overseeing the case, because the company will have had multiple opportunities to dismiss this case before it ever gets to a jury. So if once it gets to a jury, that means a judge has decided that there are some fact questions here. There aren't legal questions, there are fact questions as to how this unfolded. But if I'm presenting this to a jury, I'm telling the jury in no uncertain terms, when you're on the floor and a man has a gun and you don't know if you're going to be shot, do you think it's correct to lose your job over it? Especially when there are laws on the books in this state that you all live in that state you have every right to defend yourself. And the
really
jury will
quick,
make a decision.
For the average person out there, and we've seen many social media posts where individuals have intervened in crimes happening in a store where they are employees. What would you tell these people to do?
Well, look, this easily could
Best case scenario, if they're not threatening your life, what would you tell that employee to do if someone's stealing stuff?
If someone's stealing stuff, it's not worth it. It's not worth it. Stand down. No need to engage or create an issue. In this particular case, it could have gone the other way. Fortunately, nobody was hurt, nobody was injured, nobody was killed. But that could have gone the other way had that individual then shot at him. Right? The storyline could have ended a different way. But by and large, don't engage unless your life may depend on it.
All right. Alfonso Kennard, employment attorney, thank you for joining us.